Good morning, council.
Good morning.
You calling in on Trilogy versus Hayes?
Yes.
All right, so anything going on that one?
Mr. Hayes, when I spoke with him yesterday, he said he was going to appear today, but we've not received a payment or anything since June of last year. He is a CDC applicant also.
Do you know whether or not, I mean, have you confirmed that he's got his paperwork in or anything like that?
He sent it to us back in June,
So we might as well adjourn it then, I assume.
most likely. But I think
Right.
the attorney is supposed to show up grand and grand, but I haven't seen her in here yet.
Okay, so Hayes has an attorney?
No, our attorney for Trilogy.
Oh, okay, gotcha. All right. We'll just see who shows up.
All right, thank you.
Yep.
Sandy wanted me to go with this and give it to you. Here's the ROA. And
Good morning.
Good morning, council. Which file are you on?
I'm here actually on several files. The first one is Havenwick Hospital, Inc. versus William Johnston.
Got it.
The second one is Covenant Medical Center, Inc. versus Dijon Partey and Advanced Stores Company, Inc.
You got more than that?
Yes, and the last one is Sun Home Services, Inc. versus Aaron Green.
What time's that one scheduled?
That one is scheduled for 9:45. First one is 8:30, second one is 9 o'clock, and then this third one is set for 9:45.
Yeah, I got it. Okay. All right,
Thank you.
we got them coming in slow.
Thank you, Your Honor.
Last one, what? Sun Homes, 9:45. Good morning, Mr. Grand.
Good morning.
How are you today?
I'm doing well.
All right. So I just talked to your manager for Trilogy versus Hayes.
Yes.
It sounds like he's got his CDC paperwork in, probably going to adjourn it.
Well, he has a CDC paperwork in, yeah. Or can we set it for a hearing? I mean, he still hasn't paid rent. The question is, how do we tie up the case without just leaving it kind of hanging on your docket for, in perpetuity?
Okay. Well, let's wait and see if he shows up then.
Okay.
All right. We'll keep an eye out.
Okay.
Morning, Your Honor.
Good morning, council. You're calling in on under one.
Yes.
What's going on with that one?
You know, that one went kind of wild. It was filed a while ago. I don't know what happened to it. My client was asking me. I think at one point both parties didn't show up. We didn't show up, neither did they. But my client recently refiled it. I have a date today at 8:30, even though the summons on the paperwork says Wednesday, the 21st. So I don't know if it got double booked or.
I have no idea.
Okay. So
So
there's
what
a
are we
hearing
doing?
today.
What are we doing with this case? Because the
You know,
last note I've got is for November. You were supposed to submit a default judgment.
Is that what the note says? I honestly,
That's what my note says for November 23rd. Defendant failed to appear, plaintiff to submit default judgment under 7-day rule.
all right, I'll submit if the court allows, I'll submit a default judgment by the end of today.
That looks like the last thing that was done.
Okay. If you allow me, by the end of the day, I can submit another default judgment. Not another one. I did submit the first one.
Okay, but if they've refiled on this case, dismiss that one. I don't want two
Okay.
duplicate files.
I'll do that today.
Okay, awesome.
Thank you, Judge.
Have a nice day.
Bye-bye.
Good morning, Mr. Katz.
Morning, Your Honor.
You're calling in on Gibson versus Pine Woods?
Yes, I am.
I don't see her in the waiting room yet. What's going on this? We just said on the no progress docket because we haven't heard anything since June.
I have no idea, Your Honor. This was a weird case to begin with, so.
Yes, it was. Yeah.
I do remember the last communication I had was I spoke to her after we had our last hearing. I gave her the information on the insurance, and that was the last I ever heard of anything.
All right. And this case was scheduled for this morning at 8:30, right?
Yeah, I'll wait.
All right. Yeah, let's give her a few minutes, see if she shows up.
Okay, sounds
Thanks.
good. I'm trying to figure out where Mr. Grand is. I mean, it seems, think he's lost.
I don't know, but it's a grand location.
Yeah.
Mr. Johnson, are you connected?
Yes, sir.
All right. So what are you calling in on? What's case number or case name?
204004.
Give me some names. Who's the plaintiff?
Havenwick Hospital, sir.
All right. And I've got the attorney on that one. Counsel, we've got Mr. Johnson on Havenwick Hospital versus William Johnston.
Your Honor.
All right, this is a pretrial today, correct, counsel?
Yes, Your Honor, it is.
All right, Mr. Johnson, a pretrial is an opportunity for me to get information about a file, so hopefully we can put it on the calendar and move it towards a resolution. Counsel, where are we at on the plaintiff's end? We need discovery. You ready for motions? Where are we at? You need some discussion with Mr. Johnston?
Yes, Your Honor, a brief discussion with Mr. Johnson. That way I can find out what the defendant's position is and we can better advise the court then.
All right, let's see if we can get you in a breakout room.
Thank you very much.
They're on their way in. They're on their way in. When he comes back, Judge, will you verify what his first name is? He's got Christopher on his ID, but on the docket it says William. Thank you.
Good morning, counsel. You calling in on Jefferson?
Yep, Jefferson Capital versus Stacy Dyson.
All right. Looks like the last conversation was back in February. Thought we had the case settled. Where we at?
My notes don't indicate we had it settled. My 1015 one we thought was gonna settle, but not this one. She was disputing the account. We did discovery, and she didn't return it, so I'm just looking for a motion date at this point unless she wants to resolve.
All right, let's give her a few minutes, see if she's gonna show up or not.
Okay.
Thanks. What's the name on that one? Thank you. Oh, they're both the same party defendant too. Right? I'm showing they're both. No, one's Dice and one's Ketchum. Yeah, yeah. All right, so we'll watch for the ladies. Should you give you a name or anything so I can find it without opening every file? It appears that I don't have that file anyhow. I think she kept that file when I took it down to her and told her calling. You might have to end the breakout rooms to get Mr. Johnson back.
Yeah, I'm going to do that right now.
All right, back on the record with Havenwick versus Johnston. Counsel?
Good morning, Your Honor. Christopher Sosson, spelled S-O-S-S-O-N-G, appearing on behalf of the plaintiff. Your Honor, I've had a chance to speak with the defendant, and at this point, the parties are unable to reach a resolution and are prepared to proceed with today's pretrial conference.
All right, so counsel, do you need any discovery?
Yes, Your Honor. Plaintiff would request 90 days of discovery.
Written only, I assume?
Yes, Your Honor.
So let's just schedule another pretrial?
Yes, Your Honor. That would be great.
All right. Mr. Johnson, discovery is just an exchange of information. Counsel, correct me if I misspeak, but Mr. Sosong is probably going to send you a list of questions he wants you to answer. He might even send you a list of documents that he's looking for if they think there's a missing document in their file or something like that. You can do the same thing. So if you have any information you need to put together your defense of this claim, you can ask those questions or request those documents from Mr. Sosong. Understood?
Yes, sir. I tried requesting information from the hospital, sir. The reason that I was sent to the place,
Yeah.
and they're telling me that they can't give me the medical records, that they don't have. They have people that sit there and watch you. That the reason they supposedly send you to this hospital. They won't give me the notes of these people that sit there and watch me, sir. I sat there for 3 days in this hospital, and they're telling me that they don't have any notes. I think it's unfair. I don't think that. I find it crazy that the hospital pays people to sit there and take notes of you, but yet they won't provide them for you in this case. Like, I'm trying to get the notes of the people at the hospital that were watching me that can sit there and say, I absolutely did nothing crazy or wrong or anything to be moved on to this hospital where I was forced to be, and kept beyond my will. But
Okay, well, here's my, hold
the
on,
Wayne
hold on.
Annapolis Hospital. Yes, sir.
Stop. Here's my suggestion. Mr. Sosong, is there any reason why he's not entitled to those records?
His medical records, Your Honor, no, I would be aware of no reason. I
That's
don't
what I
know
thought.
if he executed a HIPAA release, but I would not be aware of any patient not being able to access medical records.
So, Mr. Johnson, here's what I want you to do. I want you to send a formal request. We're open in discovery now. So I'm going to ask you to send a formal request, just means send a letter to Mr. Sosong asking for those records from, date certain, so on and so forth. Now that's part of our discovery. You follow me?
Yes.
So
Sir.
he's going to send you questions, I'm sure. So feel free to send some requests back.
Okay.
All right.
Yes, sir.
The hospital might just be putting you off because this is in litigation and they don't want to do anything wrong. Well, now the attorney's involved. The attorney can get the information you're asking for, or get back to me with a reason why you can't get it.
Okay.
Okay. Mr.
Yes, sir.
Sosong, anything else to discuss on this one?
Nothing for plaintiff, Your Honor. The
All
court
right,
will
Mr.
just,
Johnson, you understand where we're at? We're just going to kick this pretrial down the road for about 3 months.
Yes, sir.
Give you a chance to have some exchange of information.
Yes, sir.
Okay. Good luck.
Thank you, sir.
All right, counsel. We'll leave you where you're at until your next one's ready.
thank you
We'll
very
send
much.
something in the mail.
Yeah, you'll get another computer generated notice just like the one for today.
Thank you, sir.
You're welcome.
Thank you, Mr. Johnston.
Paula, let's see who this LG phone is.
Okay.
Hello,
LG, what's your name?
Anastasia Turner.
Turner.
Yes,
And what time is you're scheduled at 9 o'clock with Beaumont, right?
yes.
All right, we're going to rename you and put you in the waiting room until the attorney checks in for Beaumont.
Okay.
Mr. Katz, are you there?
I am.
All right, I just note that the notice for today said parties should be in the waiting room at 8:15. It's now 8:45. I don't see Ms. Gibson. Case dismissed for lack of progress.
All right. Your Honor, there was a counterclaim on this one?
There was.
There was.
Why'd you do that? You made things complicated.
Well, maybe it might make sense to dismiss it all, but I don't know.
Well, you want me to put you on mute while you consider that?
Well, I guess if I'm going to proceed with the counter, do I get a judgment today on that?
You know what? Let's find out. Submit it under the 7-day rule. Let's see what she has to say.
Okay, sounds good. Do you want me to put the facts on the record as far as the amounts?
Go ahead.
All right. Your Honor, this originated as a claim by my client for non-payment of rent. The court awarded a judgment in my client's favor after a lengthy hearing for a balance of $2,161. Defendant was to move out by the end of September of 2019. She failed to. Ms. Gibson then filed a claim of her own against my client. I then countersued for the amount of the judgment of $2,161 plus the October rent, which she did not move out, plus damage to the apartment. After removing the $800 of security deposit, that left a balance due to my client of $3,742, requesting a judgment in that amount in favor of Pinewood Holding Group.
All right, submit it under 7-day rule. Let's see what she says.
Thank you, Your Honor.
Thanks. You got anything else with me today?
I don't think so.
All right, enjoy your day.
Thank you. You too.
Judge, I was just notified by Civil Department on 1, 2, 3, 4, 5 dismissals. Do you want the names?
Sure.
Okay. At 9:15, Country Meadows versus Kimbrough and Spearman. Rossonville versus,
Hold
I'm
on.
sorry.
I want to get the files off my stack too.
Okay. They're all at 9:15, so.
Yeah, and that first one, I don't even have a file. Countrywood,
Country Meadows,
not even here. What's the next one?
Rossonville Woods versus Hall.
Okay.
Rossonville Woods versus Weinman,
Yep.
Okay. Country Meadows versus Farley and Farley,
Yep.
and Swan Creek versus Schultz and Schultz. They're all dismissed.
Thank you.
You're welcome.
Mr. Grand, what's your pleasure on Trilogy?
Your Honor, I would ideally like a default judgment of possession only with a writ date of June 30th, 2021.
Why don't you submit it under the 7-day rule? We'll give Mr. Hayes a chance to give me an argument.
Will do. Thank you, Your Honor.
You're welcome.
Have a good afternoon. Or, I'm sorry, good day.
You as well.
Thank you.
About Jefferson versus Dyson. Counsel, you ready to do something on that one?
I'm ready, Your Honor.
This was adjourned for written discovery. I'm assuming you got what you needed on discovery?
Well, we sent it out. Ms.
Responses?
Dyson did not respond to it, no.
All right. And just for the record, I'll note that this matter was scheduled at 8:30. That means Ms. Dyson was supposed to be in my Zoom at 8:15. It's now 8:51. Why don't you submit a default judgment?
Will do, Your Honor. It's going to be a judgment for a total of $1,014.83.
Thank you.
Yep, it's under the 7-day, I'm assuming.
In this case, I don't think we need to.
Okay,
She-
so do
She's
you want
been
me to
here. We
email
explained
her
what
or
was
what
going
do-
on.
Hmm?
I said she was here the last time. We explained how this worked and she didn't show up today. So just go ahead and submit it.
Okay, by mail or by email or what do you?
Either way, we can handle either way.
Okay,
Your call.
all right, thank you.
You're welcome. Mr. So-Song, I'm ready to call Covenant versus Party.
Yes, Your Honor, I'm ready.
This one was scheduled. This was scheduled at 9.
Yes, Your Honor, it is.
Well, let's give them a few more minutes then.
Understood. Thank you.
Thank you. Council back on with Covenant. This is plaintiff's motion for a judgment against the garnishee defendant, correct?
That is correct, Your Honor. Yes.
And I'm assuming that you haven't heard anything from Advanced Stores.
No, Your Honor. Our office does not.
I just had somebody pop in with an iPhone. Let's find out if they're related to this case.
I'm sorry, I'm in the wrong courtroom.
You know where you're going, Ms. Murphy?
Yes, I was looking for to watch Matthew Lewis's case.
Okay, I don't know what Matthew Lewis's case is or where that's at.
Yep, I found it. His sister
Okay.
just typed it to me. Thank you.
All right. All right, iPhone, what's your name?
I apologize, Your Honor. I thought my name was on there. This is Hal Burke, attorney for Beaumont on a
Good morning.
case against Miss Turner.
Yeah.
Can
Ms.
you see?
Turner?
Can
Ms.
you
Turner's
see
in
me?
the waiting room.
Okay, great. May we go into a breakout session? Maybe she and I
Sure.
could resolve the case.
Sure. Let's bring her in meeting so we can put her in a breakout room with you.
Thank you.
Hello.
Ms. Turner, we're going to put you in a breakout room with the attorney for Beaumont.
Okay.
Thank you, Your Honor.
You're welcome. Ma'am with the red mask, what's your name?
Amanda Farley.
Farley, thank you. All right, Ms. Farley, you're here on the Country Meadows case?
Yes.
Yeah, that has been dismissed this morning. Country Meadows dismissed that.
Okay.
You're all set.
All right. Thank you.
All right, counsel, back to Covenant. I'm just looking, I don't know if I have a judgment. Do you know if you submitted a judgment?
No, Your Honor. I don't see that we submitted a proposed judgment to the court.
All right, why don't you do that?
I will submit a proposed judgment for the current judgment balance is $20,173.56.
All right,
And I'll submit that under the 7-day order, Your Honor.
thank you.
Thank you very much.
All right, we're getting to the end. We got one more for you, right?
Yes, sir. That's at 9:45, so I'll just I'll wait in the court's breakout room. if
Thank
that's-
you. Thank you. Awful lot of downtime.
Civil Department.
Yeah, I don't like all the downtime.
Okay,
Any ideas?
I don't know. Right now I'm sorry, Judge.
That's all right.
Right now we're scheduling 6 and at a time every 15 minutes.
Yeah. One thing that we did wrong using my 2020 hindsight
Uh-huh.
is setting a lack of progress in the middle of the docket,
Okay,
because we know most of those at least aren't going to have any actual work for me.
right.
So maybe,
When I did it, I noticed that and I was thinking about that.
yeah, maybe what we should do, of course, we don't want to take, like pallets had 4 of them. We don't want to sprinkle those out throughout the morning. But maybe set those up first thing in the morning or something like that, and a couple cases with it, a couple not regular cases with it or something.
Okay,
Just have to think about it.
okay.
All right, thanks.
Judge, Mr. Burke is back from the breakout room.
Yep. All right, Mr. Burke, your appearance for Beaumont, please.
Yes, Your Honor, this is Hal Burke. I'm the attorney for the plaintiff Beaumont, as you stated. Thank you.
And Ms. Turner, you can hear me?
Yes.
Good morning.
Good morning.
All right, Ms. Turner, this is a adjourned date for a pretrial. So counsel, where are we at?
Your Honor, I think we're very close. Again, I defer to you, of course, with your permission. What I'd like to do, and I think could be done today, and Ms. Turner and I had a pleasant conversation in the breakout room. I'm going to call her later today after reviewing one thing she mentioned regarding her file. And I think she and I will be on the same page as to what she owes and candidly what she probably does not owe. And with your permission, if we could adjourn it one last time for a pretrial or do whatever you would suggest as far as procedurally, I think we'll resolve it before any additional court date.
All right, well, here's what I'm going to do. I talked to Civil about this the other day. We're just going to put it on our no progress docket at least 3 weeks down the road. That way, if you settle it, but we don't have the settlement yet, we'll just dismiss it and then we can fix it later.
Sounds fair, and I think we will settle it.
Awesome. Good luck, Ms. Turner.
Thank you.
All
Have a
right,
great
counsel,
day.
You too.
You too. Bye-bye.
Thank you, Your Honor. Thank you.
Thank you, Jim.
These are all set, correct?
They are.
Yes. Good morning, Ms. Johnson.
Good morning.
What case are you on, please?
204949 and 204593.
And are you the attorney or?
No, I'm the plaintiff.
Okay, 204. Give me the names, please.
Teresa Johnson for the plaintiff and the defendant Elizabeth Marie Smith and Michael Olsey. This is from an adjournment from last month. Because I had mentioned to them I was filing bankruptcy, so I assumed that you all received the case number
Hey,
for the bankruptcy.
Hang on just a minute, okay? What time were you scheduled?
9:15 to be here and 9:30 for the hearing.
Thank you. Hang on, please.
You're welcome. Oh, it's 9:12.
Two of them, and they're both scheduled for 4/27 at 10:15 a.m.
Okay. Ms. Johnson, I just spoke with the civil supervisor. She said both of these cases are scheduled on April 27th at 10:15 before Judge Green.
Oh, okay. All right.
Was Judge Green your judge before?
Yeah.
Yes. Okay, thank you. We'll just check in on the 27th into Judge Green's courtroom.
May I ask a question? That's the day that I'm also supposed to be vaccinated and stuff, and I'm supposed to be there at like 9 in the morning. And
I'm going to have to call the civil supervisor, okay? I can't change the docket or anything like that. So just call the civil department and talk to them about it.
Okay. All right. Thank you so much. Have a great day.
You're welcome. Bye.
She said that, okay. Oh, you're on.
Good morning, Galaxy Note 8. Can you tell me what your name is, please?
Christopher Typely.
Spell the last name.
T.
Taipale.
Correct.
Okay, hang on just a minute. Okay, now we've got your name. Hang on, I'll get you checked in and I will let Judge know, okay?
Okay.
Council, I've got Aaron Green in the meeting. Mr. Green, unmute.
Morning, Your Honor.
Good morning. Council, your appearance for Sun Homes, please.
Thank you, Your Honor. Christopher Sosson, spelled Sossong, appearing from Bell Law Office on behalf of the plaintiff.
All right. And if I've got this right, today's the date and time set for Mr. Green's motion to set aside a default judgment, correct?
Yes, Your Honor.
It is also set for a hearing on the defendant's objection to garnishment as well.
All right. Well, seem to make sense to talk about the default judgment first. So, Mr. Green, go ahead.
Well, Your Honor, back when we were living in the rental unit, we had switched to a month-to-month base lease. And during that time, we had incurred quite a few damages to personal property. And the park manager had told us at the time that because we are not as happy as we should be there, after a few reviews on Google that he saw of ours, he told us we could leave as long as we provided 30 days to vacate and everything would be okay. Now, upon moving into the unit, we took multiple pictures as well as filled out an initial check sheet of the damages that were already done to the unit prior to moving in. When we moved from the unit, we took pictures of the unit as well. I submitted those all the day that I had submitted the objection to, or the motion to dispute judgment. The pictures were showing the fact that they had intended to repaint or tried to charge for repainting of all the walls and charged it as double. When we moved in, they used a brown paint on the interior and white paint as trim work as opposed to actual trim work. And this, when we moved out, was listed as one of the damages that were done to the unit that we were being charged for. In the initial check sheet of the damages to the unit, we also listed that there were damaged blinds. There were stains, red stains and bleach stains on the carpet. It actually lists which rooms for some of the damages. On the bill of charges that they had sent, they listed a refrigerator door handle being broken as one of the charges. This was a work order that was incompleted. It was actually created, an issue created by a work order that they came out to do for a hot water tank. When they sent the maintenance technician out to do the hot water tank, he took out a hot water tank that was smaller from a cavity next to the refrigerator and installed a much larger one. He didn't realize that the much larger one wouldn't fit into the cavity and had to cut the wall a lot. And it was at our unit until almost 11 p.m. that night. In the process of trying to move that hot water tank in, he broke the door handle to the refrigerator, trying to get it past the corner into the wall that it needed to be at. They were supposed to send a repair technician out to fix the refrigerator door handle, and that never happened.
All right, we're getting into a little bit too much detail, Mr. Green. Two questions I look at when I decide whether or not I'm going to set aside a default judgment. Number one, is there a valid or meritorious defense to the underlying claim? So some of these things you just mentioned would go to that. And number two, do you have good cause why you didn't do whatever led to the default? So in your case, there was no answer filed, I believe.
Yes, so I received some follow-up paperwork from Vela Law recently showing that they had sent out documents, but they sent it out to an apartment that I lived in more than 4 years ago, maybe 5. It was actually an apartment that I had held prior to moving into the rental unit in Sun Homes. So I never received the paperwork at the address that I'm currently at and that I've been at for almost 3 years now.
So your argument for good cause is because you were never notified of the underlying lawsuit. Is that what your argument is?
Correct. I was not aware of the lawsuit or garnishment until my human resources department approached me 3 days before the garnishment began that this was happening.
All right. Excuse me. Mr. Sossong, response?
Thank you, Your Honor. Your Honor, the defendant had entered into on December 16th of 2016. The defendant entered into a manufactured home lease agreement for the plaintiff to provide the defendant with housing. And in fact, from what I've heard, the defendant concurs and agrees with that. And pursuant to the terms and conditions, the defendant was to remit monthly payment for rent, utilities, and other fees during the course of his tenancy. He defaulted on the terms and conditions of that ongoing lease agreement, failed to remit monthly rent, as well as payment for utilities and other fees as promised. Attached in Exhibit 1 is a final statement of security deposit account.
All right, I got to cut you off, counsel. Let's talk about the motion. Question number 1, meritorious defense. Question number 2, good cause.
As it relates to good cause, Your Honor, this court issued an order regarding alternate service on October 6th of 2020. And on October 28th of 2020, the defendant was served in accordance with the court's order regarding alternate service by first-class mail and certified mail to 9192 Parkwood Street, Belleville, Michigan, 48111. That's contained in Exhibit number 2. So service in accordance with the court's order regarding alternate service was accomplished on October 28, 2020. Additionally, service was accomplished on October 30th of 2020 as the defendant was served by tacking and posting at 9192 Parkwood Street in Bellevue, Michigan as well. And that's contained in Exhibit 3.
Let me stop you just for a minute, counsel. Mr. Green, is that Parkwood address the one that you lived at before you were at the Sun Home?
No, Your Honor. Actually, that is a mailing address that was used prior to Sun Homes. That is my cousin's actual address, and we don't really talk. So there's no way that I would have known that I was receiving mail there. That was from today, probably 6 years ago.
All right, so roughly the fall of 2020, what were you using for a mailing address? What address did the post office have for you?
30870 Palmer Road, Westland, Michigan, 48186.
Your current address?
Yes, that's correct.
All right, counsel, I'm assuming that the firm did some kind of a postal check before they submitted the alternate service request?
That is typical and standard, and I'm looking for that right now.
Okay, I just found it. So as of July 2020, the post office still said the Parkwood address was your address, Mr. Green.
Your Honor, I've been receiving mail at this address since 2019. The electric bill has been in my name here. Most of the utilities are in my name at this address. My cars and both of my vehicles are registered to this address, as well as the insurance that's provided for them.
And I'm not by any stretch of the imagination calling you a liar. I'm just telling you this is how we got down this rabbit hole with the alternate service, because the post office told the law firm, the plaintiff, that Parkwood was your address.
Okay.
All right. Go ahead, counsel.
And so, Your Honor, it would be plaintiff's position, given the postal check, given the court's order regarding alternate service, that in fact service was accomplished to the address that through our due diligence we knew to be the correct address for the defendant as it relates to good cause. Now, as it relates to meritorious defense, there's no dispute of fact that the defendant entered into a lease agreement with the plaintiff. The only dispute of fact here that would go to meritorious defense is a question of damages. Now, the defendant's attacking the underlying validity of the judgment as it relates to damages. The defendant seems to indicate that there was some damage, but he's contesting the extent of the damage. I don't know that the defendant, by submitting pictures and speaking as to the damages, has established a meritorious defense. Certainly, the defendant, along with his motion, has attached some pictures, but I don't know that the defendant's proofs established that there is a meritorious defense to the claim. And so, given that he's failed to meet both good cause and meritorious defense, plaintiff would respectfully request that the court deny his motion. Thank you.
You're welcome. This type of case puts me in the inevitable position where I have to say that unfortunately, I don't trust the U.S. Postal Service in their record keeping. So I don't think that we can rely on the alternate service based on a bad postal check. And as far as the meritorious defense, from what I got out of Mr. Green this morning before I cut him off, some of the charges in the complaint are questionable. So I'm going to set aside the default judgment. I will also quash the garnishment that's in place. Counsel, why don't I do this? Why don't I stick you two fellows in a breakout room? Maybe we can actually have a meaningful pretrial today.
Absolutely, Your Honor.
All right. Mr. Green, you with me so far?
Yes, thank you, Your Honor.
All right. Paul, if you'd stick these gentlemen in a breakout room.
They're on their way in.
Morning, Judge.
Good morning, counsel. How are you today?
Good, how are you?
Excellent. I'm going to pronounce it Typel. Mr. Typel, are you connected?
Mr. Typley? Yeah.
Typley, good morning, sir. Counsel, your appearance for Midland.
Omar Nader on behalf of the plaintiff.
All right. Mr. Typley, this is a pretrial schedule today. That's an opportunity for me to get some information from you two gentlemen, so I know a little bit about what's going on with the file, so hopefully I can put it on the court calendar and move it towards a resolution. Counsel, where are we at from the plaintiff standpoint? Do we need discovery, motion date? Where are we at? Need some discussion with the defendant?
I would gladly discuss it with him. I don't have a copy of the answer, so I'm not sure what the situation is.
Yeah, let me see what I got for you.
I'm sorry, Judge?
I said, let me see what I've got.
Okay.
Yeah, I've got it's a one pager that was submitted to the court for an answer. Mr. Typley, the answer you submitted to the court, do you by chance have that electronically so you could send it to counsel?
I do.
All right, counsel, if you don't mind, why don't we do this? Why don't I put you two gentlemen in a breakout room? Maybe you can give an email address. He can send that to you real quick, and maybe you can have a meaningful conversation this morning.
Yeah, that sounds good to me.
Mr. Typley, that work for you?
Okay.
All right, we'll put you in a breakout room and then you can exchange email.
Thank you, Judge. I do have
Got
two
it,
more,
Paul?
but coming up.
Give me a defendant's name on those.
Second one, I think you're May Melvin.
Nobody in the waiting room yet.
Okay, yeah, I think it's a 9:45. So
Okay, we'll watch for him. Thank you.
Thanks.
Ms. Jabro, what are you calling in for?
I am here on the Frankenmuth versus Estravanu file.
All right. All right, so they were supposed to be in the breakout room by 9:15. I don't see them yet, so we'll wait a few minutes and then you can request a default.
Great, thank you.
Thank you.
Judge, we do have one more dismissal that I was just notified of. Maple Leaf versus Blunt and Booth at 9:45.
Good morning, Mr. Cox. Which file are you on?
Good morning, Your Honor. I've got the matter of Frankenmuth and Ostravano.
All right. And I've got Ms. Jarborough.
Good morning.
All right. So Frankenmuth versus Ostravanu. Appearances.
Good morning, Your Honor. May it please the court, Keith Cox of Ingber and Winters on behalf of the plaintiff, P59146.
Good morning, Your Honor. Natalie Jabor on behalf of defendants, P78307.
All right. Good morning. I had a chance to look at your pleadings, so why don't you hit the high points and we'll go from there.
Since Your Honor has taken a look at it already, I will rely on most of my brief. However, I would like to note that Mr. Cox's response was not filed timely. We received it on Thursday. So I do have some arguments that would offset what he sent. Since Your Honor has already read my first brief, I'm okay with Mr. Cox going forward with any highlights that he may have, and then I can respond.
Okay. Mr. Cox, anything to add to what I read?
Judge, just that, I think there's a real question there as to whether or not this negligent act by these defendants was incident to the motor vehicle accident as opposed to arising out of. I would concede that the case that they cite, the Northland case, is more on point factually relative to our case. But unfortunately, when you start following the chronology of that unpublished case, and then the way the Court of Appeals treated it the very next year in the Tuttle case, and the court sort of revealed its thinking, which was overly broad. It said basically, hey, tort liability is to be precluded whenever an automobile accident's involved. And then the Michigan Supreme Court said, no, there is still tort liability out there. It still exists. Michigan no-fault law doesn't abrogate all of it. And so it does in instances where it's incident. Now, the Cow case factually doesn't fit as well as the Northland case, which is sort of the conundrum, I think, for the court, is to say, okay, I think the law as applied to this case should result in a factual question as to whether this was incident to a motor vehicle accident, whereas the factual case in the Northland case is more on point. But it's unpublished, Judge, and unfortunately, it's also not really something that was followed down the line with the Tuttle cases. And I highlighted the Court of Appeals in the Tuttle case to kind of show where its thinking was, and then how that thinking was changed by the Michigan Supreme Court. So our position simply is that, the loading wood into a truck is a negligent act, and that it is not really arising out of the maintenance or ownership or use of a motor vehicle. It is distinct and incident too, and that's why it establishes liability on behalf of the defendants.
Thank you. Mr. Yarborough, am I saying your name correctly, by the way?
Jaboro, that's okay.
Jaboro, go ahead.
Thank you, Your Honor. So two things here. The first is there's no evidence to establish that the loading of the wood itself was negligent. The wood fell off while the vehicle was in transit, which then falls under arising out of the use of a motor vehicle as a motor vehicle. It was loaded onto a truck. Trucks are routinely used to be transporting objects. So that's first. Second, I've got a few cases that do indicate otherwise as to what Mr. Cox was saying. Walega versus Walega, 312 Mitchap, 259. Injuries directly related to use of a truck as a mode of transportation. Injury results from force of motor vehicle driven in a normal manner, which is what was going on here. And it arises out of the operation or use of the motor vehicle as a motor vehicle. Again, trucks are used to routinely transport heavy objects. But one of the other cases that I found was Travelers Insurance as a subrogate of Pine Knob Wine versus U-Haul. The appropriate remedy, so this is a similar type of case in which Nuri rented a box truck from a U-Haul, used the U-Haul to transport some objects, stopped at a Pine Knob wine shop in Clarkston. While he was maneuvering the truck hit the building itself and caused damage. And the court there found that under the no fault statute, the defendant who causes economic damages is not personally liable to the injured party. The appropriate remedy for economic damages, including property damage, is a direct action against the tortfeasor's insurer. Here, the insurer was not named in the suit, rather both defendants, the owner and the driver. And so Your Honor, we disagree with Mr. Cox's interpretation, and we do believe that tort liability is what controls here, meaning $1,000 is the max.
Okay.
Judge,
Anything
and
else?
Real quick, Judge, I would concede driving a truck into a building is the use of a motor vehicle. So, I mean, I admittedly, I haven't read the case, but just listening to the recitation of the facts from counsel, driving the truck into a building, I think would probably fall under the No Fault Act. That's the use of a motor vehicle. The vehicle here didn't cause this accident. This wasn't two cars hitting each other. This wasn't a car hitting a building. This wasn't even a car hitting a tree. This was plywood flying out of the back of a truck that wasn't properly loaded. And so plaintiff's position is that is incident to a motor vehicle accident.
Right. Thank you both. I always appreciate well-argued motions. I am going to side with plaintiff on this. I think it's a question of fact whether or not the plywood hitting the injured party's vehicle was negligence or incident to the motor vehicle use. So where do we go from here? We ready for a trial date? You need some discovery. We need some discussion. So I just give you some bump it down the road for a pretrial. What do you want to do?
I would be in favor of a pretrial, Judge, given the fact that the case isn't going to be decided on the law. Maybe there'd be some additional discussions the parties might be willing to have. I think we both sort of refrain from any of that type of discussion on the basis that we figured maybe this would go one way or the other legally.
You want me to just kick it down the road for a pretrial?
That's what I would suggest. And then we could, and then at that point, also both parties could identify whether there's any discovery. I would maybe keep discovery open. I don't know if I know this court issued a scheduling order, I suspect previously. I'm not looking at it.
Let's just knock it down the road for what, 60 days ish?
Okay.
Written discovery open until then?
That sounds what plaintiff would.
Mr. Worrell at work?
Yes, Your Honor.
All right. Anything else, folks?
Judge, before I get booted out of your room, I did have a 1015 matter that I was trying to get off your docket. This is not pertaining to the case.
That's all right. Give me a name.
The name of it was Michigan Education versus Brown, and we had submitted a stipulation to adjourn. Did it get bumped?
Civil Department got that one already. Thank you.
Okay, very good.
Your Honor, does your court require, would you like for me to file an order, or does the court just issue?
Oh, the court's lazy. So if you want a written order, you got to submit it.
Okay. And then we will get new dates as to when
Correct.
the next pretrial will be? Okay,
Yep.
great.
Yep.
Thank you
Good
so
luck.
much.
All right. Thank you, Judge.
Excuse me, Judge.
Yes, sir.
We were having pretty good conversation, but we got kicked out of the breakout room.
Okay. That was with Mr. Tapley, right?
Yes.
Okay. Paula, can you put those fellows back in?
I'm sorry, who was it with?
Midland and Tapley? And Mr. Sosong, did you have enough time with Mr. Green?
We did. We kind of came toward the end there and left the breakout room by default, but there are issues of fact here. The issues of fact center around defendant's claim as to the amount of damages. And so I think it would be appropriate, Your Honor, if the court's going to conduct today as a pretrial, I would ask that the court consider a 90-day period of discovery and then perhaps reset or set a pre-trial conference in this after that period of recovery.
Would mediation be of any assistance, do you think?
Mediation?
Yeah, we've been doing a lot with the Wayne County Neighborhood Mediation Center, Dispute Resolution Center.
Respectfully, plaintiff would decline it, and I'll tell you why, Your Honor, at least from plaintiff's position. This is an issue about damages, and from plaintiff's perspective, it's going to provide the defendant, I think, with evidence in support of the damages that
Okay.
it expensed the defendant for as a result of his tenancy. So I think
Okay.
it's a proof issue that I
Yep.
don't necessarily know whether
Okay,
mediation. or
so let's
evaluation.
do this. Mr. Green, if you are in agreement, we'll adjourn this for approximately 90 days for written discovery, and then we'll have another schedule for pretrial, so we can have another discussion with the three of us. Discovery just means exchange of information. So council's probably going to send you a list of questions. You can do the same. Understood?
Yes.
All right, any questions?
No, Your
None.
Honor.
Thank you.
All right, good luck, gentlemen.
Thank you very much, Your Honor. Thank you,
You're
Mr.
welcome.
Green.
And thank you.
Judge Michael Beach is the one that I brought in the appearance this morning on Qual.
Yep.
And I'm not sure if we have the other side.
We don't yet. And let's see who Jen Wilburn's for.
Okay. I just brought in his attorney, so.
Attorney Wilburn, are you connected?
Yes, I am.
Who are you calling in for, counsel?
We have a motion this morning for Metro Commons.
Scheduled when?
9:45.
Okay, versus Lovedell?
Yes.
All right, watching for that person. Let's find out who this iPhone is. iPhone, what's your name?
Chris Jodway.
And what case are you on?
This is case.
Citibank, 10 o'clock.
Yeah.
Just
Yep.
found you. Okay, we'll put you in the waiting room till we're ready for you.
Thank you.
Let me rename him, Judge.
Good morning, Mr. Beach.
Good morning, Your Honor.
And you're appearing on behalf of?
CACH.
All right. And I think we've got Mr. Quah connected, correct, sir?
Yes, Your Honor.
All right, good morning.
Good
All
morning.
right, so what do we got scheduled today, Mr. Beach?
Your Honor, we had an adjourned objection to a garnishment. The last time we were here, you gave us an opportunity to have Mr. Quah submit a fraud packet.
Right.
And we also were able to do some investigation on our side.
Okay.
So, and Your Honor, I sent over earlier this morning, I faxed it over, I don't know if I made it to the file, some statements that we were finally able to get regarding this underlying account.
They did come in. All right, so where are we at then? I'm assuming these statements also went to Mr. Quah?
You know what, I just got those in, so I faxed them over. I can email them over to Mr. Quah too. I know I couldn't mail it today. I know it wouldn't get to him, but
Sure.
if he can get his email, I can email those over.
Okay, why don't we do that? And then see if we can have some meaningful conversation today.
Okay, Judge.
right.
You want to recall it? I'll go get these.
Yeah, I'm just gonna stick you fellas both back out in the waiting room.
Okay, yeah, I just need to get his email address.
Yep.
Okay.
Go ahead, Mr. Quah.
Yes, it's ISOMEAHKWAW@gmail.com.
ISOMEAHKWAW@gmail. Okay.
All right, so we'll put you in a breakout room. We'll see you in put you in the waiting room. We'll see you in a few minutes.
Okay, thank you, Judge.
Brandy Courage has a number behind her, but I don't see it on the docket.
Good morning, Brandy. Which case are you on?
Hi,
Hi, I am on the United Labs regarding Argy Watson, which is 202542.
All right, you represent United?
No, I represent Nationwide.
Okay. Oh, Mr. Betts is on United. All right, haven't seen Mr. Betts yet this morning, so we'll watch for him.
Okay, thank you.
Yep.
Ready, Your Honor, if you.
All right. We're
Is
just
he
waiting for
still in
Mr.
the
Tapley to
breakout
come out.
room?
Yeah, he's still in the breakout.
I'll bring him in. And Mr. Betts just went into the.
Yep. Mr. Tapley, you on?
Yes.
Okay. Council, where are we at on Midland?
Yes, Your Honor, we did have a chance to speak. We did come to an agreement. We are going to email Mr. Tapley a consent judgment just for the damages, no statutory attorney fee, no cost. In that consent judgment, we're also going to put language that says plaintiff agrees to take no collection activities for 90 days. And then hopefully we'll just stay in touch and see, after 90 days, if he can set up a payment plan with us.
All right, awesome.
If not, we'll talk about our hardship again. Continue.
Okay, so I'm going to be getting some paperwork on a consent judgment from the parties.
Yes.
Okay, so what we're going to do, we're trying something new with the civil department. Cases like this, instead of just adjourning, we're just going to put it on a no progress docket with the idea we'll get your documents before then, or you lost it. All right, Mr. Tapley, you understand that?
Yes, sir.
Any questions, sir?
No, sir.
All right, Mr. Nader, have a nice day. Mr. Tapley, you as well.
I'm still with you on those. I got two more with you.
Oh, that's right. Then I won't kick you out. All right, let's bring Mr. Betts in on United. All right, good morning, counselors. Appearances on United Lab versus Nationwide.
Good morning, Your Honor. John Betts for Plaintiff United Lab RX.
Good morning, Your Honor. Brandy Koretich on behalf of Defendant Nationwide.
All right, last time I had this file in front of me was March 16th. Looked like there was a possible settlement. Where are we at?
Well, Your Honor, this is a lab testing bill for a lady named R.G. Watson. She has her own separate suit pending. As I understand it, the insurance company wants to take her deposition, primarily to see if there's any other insurance available. This is an assigned claims case. That deposition has been scheduled a couple times. I think if we adjourn this out 30 or 45 days, that deposition will either be conducted or perhaps in her circuit court case, I think the insurance company intends to file a motion to compel or dismiss or to do something to force her to cooperate.
I'm okay with that as long as you both agree. You're muted, counsel.
Sorry about that. Yeah, we do actually in the underlying case have an order compelling her to appear for a deposition. It was supposed to occur on April 14th, but she was apparently having problems getting time off of work. So as a courtesy, we're going to try to reschedule that. Right now it's scheduled for May 3rd, assuming that it goes on May 3rd. Hopefully we'll be able to resolve this case.
Okay, we'll adjourn it then.
Thank
Good
you.
luck. You're
Thanks.
welcome.
Thank you, Your Honor.
Be well.
You too.
Looks like the attorney for Citibank just checked in.
Go ahead, bring him in.
Christopher Jodway is the other one.
Yeah, bring him in. All right, Mr. Jodway, are you connected? Mr. Jodway, can you hear me?
Yes, sir. How you doing?
All right, your audio really stinks.
Okay, hold on here.
Thanks.
Hello? Is that better?
That's better. Much
Is this
better.
better?
Counsel, your appearance for Citibank, please.
Yes, good morning, Your Honor. On behalf of Citibank, P 125.
All right, Mr. Jodway, today's the date and time set for a pretrial. A pretrial is an opportunity for me to get information from both the parties. So hopefully we can set the file on our calendar and move it towards a resolution. Counsel, where are we at from Citibank standpoint?
Your Honor, we have not received a copy of the answer. All we've received thus far is a copy of the pretrial statement. Obviously we want to get a copy of that answer to figure out what defendant's position is on the matter. But at this point, I guess we'd request discovery, 60 days, and then time for filing of motions.
All right, so Mr. Jodway, you submitted an answer to the court dated February 1. To whom it may concern, I'm now aware of the debt and will be happy to make arrangements for payment of $100 a month until paid in full. That's your answer?
Correct.
Counsel, that probably means you two should have some conversation in a breakout room this morning.
Yes, that changes things.
I think so. All right, Mr. Jodway, we're going to put you in a breakout room so you can have some private conversation with the attorney.
Thank you. It's just hard to hear. I have to have my ear up to the phone.
No problem.
Thank you.
No problem. We'll see you back here when you're done talking. Paula?
Okay.
They're on their way in.
Good morning, Mr. Conti.
Good morning, Your Honor.
Am I remembering this case correctly? Mr. Markel, we always called him, right?
Yes, Your Honor.
All right, so let me see if we can have any success with that.
All right, Your Honor.
You're trying to set aside an installment payment plan, right?
Yes, Your Honor.
All right, let me see if I can get him on the phone.
Sure.
Hello.
Mr. Markel, please.
Yeah, go ahead, Judge.
Good morning. How are you?
I'm good, boy. I try to get a hold of you. I ain't having no luck.
No problem. I've got Mr. Conti on my Zoom. He's the attorney for Lakeshore, if you'll remember.
Yes, sir.
All right. And Mr. Conti, can you hear Mr. Markel loud and clear?
I can, Your Honor.
All right. Go ahead, counsel.
Your Honor, this is a motion to set aside the installment payment. I believe we provided certification that Mr. Markel failed to meet the requirements of the installment plan, and we're simply looking to set that aside at this point. I believe Mr. Markel objected because maybe some things happened in his life that prevented him from doing so. I'm okay. It's just that since the other plan is now kind of out the window, if he wants to enter into another one that's similar, I'm fine with that, Your Honor. We just need to get the first payment relatively soon.
All right. If you don't mind, I'm gonna step out of my judicial role. Mr. Markel, Mr. Conti says he's not adverse to an agreement, but he just had to do something on that old one because nothing happened on it. Are you in a position to make some payments?
Yes, I just got back to work as of Friday, Judge. So,
okay.
Yeah, I'm in pretty good shape now. It's just that we
Sure,
didn't have any
sure.
work. There was nothing going on because that COVID stuff. And
How soon can you send some money their way?
I'd like to do it. But the end of next month would be all right.
End of May?
Yes, sir.
How much?
Well, whatever it was, I think it was 160 some dollars. But I don't need. To be honest with you, I was looking it up today. I don't even know where to send it to. I don't know where to send it to you, Judge.
I can help you with that. So you're proposing 165 a month starting on May 28th?
Yeah, that's fine, Judge.
Mr. Conti?
That's fine, Your Honor. But I'm going to ask, Your Honor, if Mr. Markel defaults again, or at least I'm just going to put it on the record that we will then seek attorney fees to set aside.
Understood. Mr. Markel, you hear that?
I heard that, sir.
Okay, and Mr. Conti, can I just give him the hogback address to send the check?
Your Honor, if I could give it to him on the record right now, a different address.
Sure, go ahead.
Mr. Markel, can you hear me?
Yes, barely, but go ahead, sir.
All right, the judge will repeat the address then, I hope. 27 South Huron Street, Ypsilanti, Michigan, 48197.
Okay, 27, what was the last part of it?
27 South Huron,
Gotcha.
Ypsilanti, 48197.
And I would put the street in because
Put that address.
I would put the street in, Your Honor, because we're loaded with Hurons in Ypsilanti.
Got it. So add street. So it's South Huron Street in Ypsilanti, Mr. Merkel.
Okay, whose name do I put on it, Judge?
You want that made out to Lakeshore?
That's fine. Lakeshore Apartments is fine.
You got that, Mr. Merkel?
Yes, sir. Got it, Judge.
All right. So counsel, what I'm going to do, let's see. I'm just going to deny the motion because, and put in the new terms there.
That's fine, Your Honor.
All right. Mr. Markel, any questions?
No, sir.
Good luck to you, sir.
Thank you, sir.
Thank you, Your Honor. I'm going to hang out because we have a 10:15.
No problem at all.
Thank you.
I'm not sure who Linda Perkins Moore is. You want me to bring her in so we can find out?
Good morning, Your Honor.
Good morning. What are you calling in for?
I was here and they sent the notice to the wrong courtroom, but I'm here on Tamara, UGH versus LLC.
The plaintiff is UGH?
Yes, UGH.
And when was it scheduled, man? What time?
Scheduled today at 9:45, but I've been in the wrong courtroom because they sent me a notice and the judge just told me to log into here.
Okay, I don't see UGH on my docket. What's the other name on the file?
Amara, her last name is Eli, E-L-Y. First name is Tamara. I have a case number.
Go ahead and give that, Paul. We'll find out what happened to that.
Okay, it's 203-408.
Give me just a second.
All right, give us just a minute, man. We'll try to figure out what's going on with that one.
Okay, thank you.
Counsel, are we ready on Citibank?
Yes, I believe we are, Your Honor.
Did we lose Mr. Jodway in the breakout room again, or what?
You know, it was breaking out quite a bit. Is he on with us now?
He is not.
He's not. We had agreed to terms of payment. And if you'd like, I could either do a consent judgment where I send that to him, have it executed, or I could do it under the 7-day rule, whatever you prefer.
Why don't you just send it to him and then get it to us?
Okay, I'll do that. So I guess if we could set things out maybe for a review, 45 to 60 days out, just to make sure that that's received back.
All right, we'll put it down the road 60 days.
Judge, I just looked it up in the computer and she's scheduled for the 27th at 10 a.m. for Judge Green next week.
All right, Ms. Moore, better to be a week early than a week late.
And Sandy just chatted me the same thing. We do have Mr. Ivanchek, who's the other party for Mr. Conti.
Yeah, that's on the Lakeshore. Yeah, bring him in. Good morning, gentlemen. Your appearances on Lake Shore versus Seba.
Good morning, Your Honor. Guy Conti on behalf of Lakeshore Apartments.
John Ivanchik on behalf of Ma'at Seba, Your Honor.
All right, gentlemen, motion day, correct?
Yes, Your Honor.
All right. All right, I did have a chance to look at the pleadings, so how about just the highlights? Mr. Vinchek?
Yeah, Your Honor, if I may, did you get all the pleadings in this? There was,
Well, I don't
okay.
know. I'll tell you what I have.
Okay.
I got, looks like the most recent thing I've got is plaintiff's response to defendant's motion. So if you responded to the response, I haven't seen it.
Yeah, I did. I hand delivered it back on Thursday night into the Dropbox. Yeah.
Okay.
And I think there's also a response to the plaintiff's motion to amend that, because I checked the ROA this morning and I didn't see any of those listed in there.
Okay. Yeah, I haven't seen those. So, all right.
Okay.
You two are good enough to give me arguments.
Well, thank you, Your Honor. Well, the highlights here, Your Honor, is quite simple. Plaintiff has not explained what their case is about. They haven't explained what the damages are. We're past discovery. They refuse to respond during discovery to explain what they're seeking, why they're seeking it, and so on and so forth. They file an affidavit or a verified account stated complaint, don't attach an affidavit. Now are asking to convert their account stated to a breach of contract. And as the court, I think, if in reading the pleading could see, this was an apartment complex. And I think you just handled another case involving the Lakeshore right before this. It's an apartment complex. My client was a tenant there. She sued the apartment complex when they locked her out. Judge Pope came up with a written order that said they being the apartment complex, had defaulted on the lease. And now here we are 7 years at this point later, and they filed this lawsuit and they can't explain what they're asking for. So, at this point, I don't know what to do. My client, the next step here is to go to trial, and the plaintiff has not explained what their damages are, and I have no way to defend it. And their only explanation is, well, you should file a motion to compel for me to explain my damages, Your Honor. That is actually written by the plaintiff in response to discovery, that I should file a motion to compel for him to explain what his damages are. That's not how we do things. It's not how discovery works. You have to explain your damages. And Mr. Conti doesn't want to do that. His client doesn't want to do that, and instead wants to continue this carnage of amending his complaint and providing a breach of contract. And, I don't see the point in doing that. You can't explain the damages. You can't explain the damages. Dismiss the case. So I'll leave the rest for rebuttal, Your Honor.
Okay, Mr. Conti.
Your Honor, as to us not being able to explain what we are asking for, that is totally untrue. We've provided the defendant with a detailed printout showing each and every charge, each and every credit. What it does not contain at the very end is the $665 credit that Judge Pope ordered. Your Honor, and we amended our first complaint when I realized that we needed to give that $665 credit. So you see that and we did that during the amendment by right period. So it was a pretty quick amendment, Your Honor. So saying that we can't say what it is that we're suing for is an absolutely ridiculous statement, because we've provided it for them. What Mr. Ivanchik is referring to is that there was an interrogatory that said, please detail each and every charge and expense. And our response was, look, to do this now, right here, right now, the client, who was represented by Rachel Russell, the office manager, said, look, I can't do that right now. I have a printout. I'll give you the printout. And that's what we did, Your Honor. And it's a detailed printout. As to the previous court case, Your Honor, this is a possession-only judgment. And what defendant is confusing is issue preclusion with claim preclusion. We are not claim precluded from trying to liquidate the various financial duties of each party to each other. We are issue precluded in that we have to give the $665 credit to the defendant, which we did in our First Amendment, Your Honor. That the issue as to breach of lease, it is true that Judge Pope ruled that Lakeshore breached the lease, but it is also true that Judge Pope said to the defendant that in order to maintain residency, she had to pay a certain amount of money, which included a $665 credit, which means that there was a breach of the lease in terms of rent as well. So we don't have a ruling on who breached the lease first, which is an important consideration in a breach of contract. We don't, what we have simply is what Judge Pope's ruling is. As to me saying in our answers to discovery that you should file a motion to compel, I did not do that nor did my client in the answers to discovery. What we did say to Mr. Ivanchek was that he's arguing that because we objected to certain discovery requests that somehow or another we're prejudiced by that at summary judgment. And I'm saying, no, that's not true. If you don't agree with our objection, then you file a motion to compel and the court makes a ruling on that and we move forward. Your Honor, the defendant is essentially looking for summary judgment on 3 grounds, C6, C8, C10. C6 is res judicata. Again, there's this confusion on claim and issue preclusion. There is no res judicata. The financial obligations of the parties have not been litigated in terms of the final liquidated at law amounts that the parties may or may not owe each other. It was a possessory only judgment, and I cited the statute in our response that says we're free to bring a suit to liquidate the damages. Your Honor, C8. The defendant argues that somehow or another we're prejudiced by not including an affidavit. MCL 600.2.145 does not contain a requirement that an account stated or an open account have an affidavit. It says specifically, in all actions brought in any of the courts of the state to recover the amount due on an open account or upon an account stated, if the plaintiff or someone in his behalf makes an affidavit of the amount due as near as he can estimate the same. And it basically goes on to say that provides prima facie evidence. So there's an if in there, Your Honor, and it dictates an evidentiary standard, not a pleading requirement. So we are free, and any plaintiff is free to bring an open account or an account stated without an affidavit, and subject to the evidentiary standards as laid out by MCL 600.2.2145. So that argument holds no water, Your Honor. So the fact that we did not provide an affidavit does not provide relief under C8. We did state a claim. We said that the account was stated. On C10, Your Honor, I think that the amount of damages as to liquidated damages is clearly at issue, but also at issue might be who breached the lease first, which of course Your Honor knows is very important as a matter of law in terms of a breach of contract case. But finally, in terms of our motion to amend, Your Honor, the defendant is somehow arguing that because they are asking for a C6 relief, that somehow or another we lose our rights under 2.116 I-5 to amend after a C8 or a C10 motion. And that's not true. There's nothing in the court rules that says, well, if you add other causes of action for your summary disposition, somehow or another the non-moving party loses its right to amend under I-5. But we're simply saying, look, we've looked at the evidence, we've looked at the discovery request, we've looked at the file even further. We want to get this right. We believe that there is more issues at law and an action for breach of contract. And quite frankly, unless we've done anything with this court that would indicate that we were dilatory after the motions for C8 and C10 was filed, we're entitled to that relief. So we believe that the motion to amend should be granted given the standard for leave freely given. Our answer to the summary judgment motions was timely. So we should be entitled to amend, and the summary judgment motion should be denied.
Thank you. Mr. Ivanchuk.
Sorry, Your Honor. Well, Mr. Conti apparently didn't read, or the only thing I can imagine here is that he just didn't read Judge Pope's opinion or my motion, because the motion and the opinion both specifically state who breached the lease. The order of events was My client was locked out. They disconnected her gate card for what Judge Pope later found was an absolutely unilateral decision that was not grounded in law, fact, or anything. She sent a letter to the plaintiff and to Lakeshore and says, hey, until you turn my gate card access back on, I am withholding rent and I am going to escrow it. And then, unlike most people, she did do that. She actually escrowed her rent. Then, after they refused to turn on her gate card access, so she sends the letter on March 28th. This is in my motion as well as in Judge Pope's opinion. March 28, 2014, she sends the letter. April 10th, proceeding in pro per, she files a small claims lawsuit against the plaintiff stating, my gate card access has been turned off. You've locked me out. You've breached the contract. And then after that, the plaintiff files a lawsuit for non-payment of rent. And Judge Pope specifically found that the plaintiff had defaulted on the contract. And in doing so, he denied them charges for late fees, charges for attorney's fees. So I don't know how Mr. Conti can sit here and say that Judge Pope did not make these determinations, which were essential to my client's lawsuit against Lakeshore that was filed first, and claim that we don't know who breached first. It's quite obvious who breached first because Judge Pope has already told us who's breached first, as well as the timeline explains who breached first. The plaintiff did. So now they want to resurrect this contract and say, well, no, wait a minute. We're going to come after you for breaching the contract that we already breached. I mean, isn't that what Mr. Conti's saying here? Because it seems like it. And Your Honor, if I may, his argument regarding the discovery requests is just absolutely ridiculous. And at no point in time, even in discovery, in the motion, or even today, does he actually explain what the charges are for. Are they for rent? Are they for attorney's fees? Are they for costs? What are they for? We don't know how they arrive at any of these numbers. They just basically throw darts at a dartboard and say, you owe $2,300. Well, wait a minute. My client's son called Credit Bureau of Ipsy, who is apparently the employer of the person who filed the lawsuit. And after he called them, they amended the lawsuit. So Mr. Conti's statement that when it was brought to his attention, he amended the lawsuit, that is not true. My client's son called Credit Bureau of Ipsy, who amended the lawsuit, and there's documents to prove that. But that doesn't really matter for today. So, you know, Mr. Conti asking to amend this case as a breach of a lease, I mean, the court doesn't need to allow it where it's going to be futile. And here it is futile. There's no reason to amend this. They can't explain what the damages are. They can't explain rent, anything. And I can't defend the case. And for him to say, well, you know, we objected and he didn't file a motion to compel and et cetera, here, you know, and I'm sure the court read through this. This was the very difficult and burdensome question I asked. Please please explain how plaintiff arrived at its claim for damages, including but not limited to the date the damage account came from, as well as an itemized statement as to plaintiff's alleged damages. And to that, the objection I got was unduly burdensome in a $2,000 case. Unduly burdensome. So I can't prepare a defense. My client is being prejudiced by the way that Mr. Conti has decided to conduct these kind of cases. And there's no basis to move forward because what Mr. Conti thinks he's going to do is show up at trial or threaten my client with showing up at trial and basically try to force her into a resolution. Every single thing that the plaintiff has done in this case on discovery has been designed to do one thing and one thing only: refuse to explain what their damages are and drive up the cost of litigation. That was just one objection that I got. There were multiple questions that went absolutely unanswered. The one that kind of really jumps out at me is I asked a question about the person who signed the complaint, who's not employed by the plaintiff and works for a separate debt collector, under a verified complaint, asked them simple questions about who they were, what documents they reviewed. When I asked them what documents reviewed, they said, we're not answering it. We're going to refuse that. So you have a person signing a lawsuit saying, or signing a lawsuit on behalf of a plaintiff saying, we don't know what they actually reviewed, but she verified. So, I mean, Mr. Conti is saying there's no affidavit. The person who verified the complaint, we have no idea what she used to verify it. And now my client's being forced to defend it. So there's no basis for this case to go forward. I ask the court to dismiss it and deny the motion to amend as well.
Mr. Conti, any response?
Your Honor, first of all, it's an absolute, I've tried not to bring Mr. Ivanchek in this, but he's casting aspersions at me. And I'm going to tell you something, Your Honor. There is not a single request for discovery that does not have an answer or a response. Okay. It's either we answered it, we objected to it, or the client said they didn't have any knowledge. As to the one where Mr. Ivanchek says unduly burdensome, we said unduly burdensome because it's duplicative of another request. That was our objection, Your Honor. Okay. And if Your Honor probably has the printout in some of the pleadings, but if I could share a screen, I could show you the printout, Your Honor. You'll see that each and every charge and credit has a description in it. Mr. Ivanchek is not representing correct facts here. We have this printout that shows each and every charge and credit and shows the amount sought for in the initial complaint. We reduced it from the $665. And as to Mr. Ivanchek talking about he's got documents that somehow or another that I figured out something because his client's son called is absolutely untrue. Okay, the truth is that I spoke to previous attorney for Lakeshore, David Fantera, who reminded me of the $665 credit, and that's how the complaint got amended. And any accusation otherwise is false. Okay, because that is exactly what happened. So Mr. Ivanchek takes a lot of guessing and misrepresents a lot of things to this court, Your Honor, because we did not say ever we will not answer. Okay, we either objected or we said we didn't have sufficient knowledge on certain things. He's asking, when he asks about the information about the person who signed the complaint, that person acts as the agent of Lakeshore. Okay, she is not employed by Lakeshore or the management company that runs Lakeshore. When he asks Lakeshore personal information about her, if they don't have it, they can't provide it, Your Honor. It's as simple as that. And nothing stopped him from making follow-up questions. Nothing stopped him from doing motions to compel. Okay. And I mean, he even comes in front of this court and represents to the court, both in writing and verbally, that somehow or another an affidavit is required by statute when the statute clearly doesn't say that. So I ask this court to take all that into consideration when it makes its ruling. We have responded. Whether or not Mr. Ivanchek likes the response is an entirely different story. Thank you, Your Honor.
Thank you, gentlemen. All right, so I'm going to grant plaintiff's motion to amend. I'm going to deny defendant's motion for summary disposition. We ready for trial? Would mediation help the parties? Where do you want to go from here?
I would like an explanation of what the damages are, Your Honor. I mean, again, I don't want to be showing up to the day of trial with Mr. Conti dragging some witness out who all of a sudden shows up and says, well, these are our damages now, when he could have answered it during discovery.
Well, Mr. Conti said at least twice today that the damages are all on that statement that you got after they provided the answer to interrogatories.
But they're not. That's my point. Like,
then I guess they'll have a real hard time establishing damages at trial, and you
Okay.
can ask for costs.
All right. Thank you, Your Honor. I'll be filing a motion limiting them.
All right. Anything else, fellas?
No, Your Honor. Thank you. Your Honor, submission of order. Shall I submit an order?
Please.
All right. I'll submit it to Mr. Ivanchek for review.
Thank you, Your Honor.
Stay well.
Thank you, Your Honor.
Mr. Najer, remind me, what's your other file?
I got two more. The next one was May Melvin. That was a 945. And then for Reese Parton, that's a 1015.
I think Parton was in for a minute. All right, let's see. Let's take Parton because Parton's in, and then we've got an unidentified phone that might be Melvin.
Sounds good.
Good morning.
Morning.
Counsel, your appearance for Crown.
For Midland Credit, Your Honor.
Oh, I'm sorry.
Omar
Nope,
Nader,
I-
on behalf of
All right. Oh, Ms. Parton's got 2 files today. Okay.
We do have Mr. Canine in the
Yeah.
waiting
Yep,
room
we'll,
too.
we'll get him next. All right, Midland Credit.
Omar Nader on behalf of the plaintiff, Your Honor.
Thank you. All right, good morning, Ms. Parton.
Morning.
So last time we spoke was back in the middle of March, and we adjourned this for some discovery. So where are we at, Mr. Nader?
We Center Discovery. Not sure exactly when. I think it was near the end of March. I can look it up if you want, but we
It
haven't
was the
received it back.
22nd is when I received it.
Did you send it back, Ms. Parton?
Yes, I did, sir.
All right, did you snail mail it or email it? How'd you send it back?
I certified mail that I had to return slip.
Can you read the signature on that slip? It might help Mr. Nader find that.
Okay.
Yeah, probably not.
Tell me when it was signed and tell me if you can read the name.
It was Chance Lee. And it was, let's see here. And it was signed on, sorry, let me check. I have a couple of them, I'm sorry.
I'm having trouble hearing you over the rustling papers.
Sorry, I said I have a couple of them here. I actually
Sorry, take
don't
your
have
time.
that one. Let's see here. They haven't resent that one back to me, but I did mail it out.
All right, and
I
you
have a-
mailed
I
it
actually
March
have my-
22nd?
No, I did not.
Judge, if I, does Ms. Parton want to talk and see if we can resolve it?
We can put you in a breakout room, sure.
If she doesn't mind.
That's
Ms.
fine.
Parton, breakout room?
That's fine, sir.
Okay. Paula, if you would.
Pardon me. Keith Haynes has 2 search warrants. He's wondering if he could do it via email, send them to your email.
Yeah, tell him to send them to my email, and when I get a break, I'll call him and swear him in.
Perfect. Thank you,
Thanks.
Judge.
Tell him that's why I've been ignoring him.
Well, he knows. I told
Yeah.
him you were on. Okay.
Miss Wilburn. Yeah, Miss
Yes,
Wilburn.
Judge.
Which one you on?
The Metro Commons and Lobdell.
All right, what time was that one scheduled, counsel?
9:45.
All right. Galaxy J2, what's your name? She's not connected. You're muted, ma'am.
Ruby Markham.
Last name?
Markham.
All right. Who's the plaintiff on that case?
She's scheduled at 10:30 and it is Mid Apartments.
Mid Apartments,
With Carrie
okay.
Seib. Carrie's in the waiting room.
All right, we will relabel you and put you in our waiting room, ma'am.
So just hang on the phone.
Yes, ma'am.
Okay.
And just leave it where it's at, okay? So that we don't have a problem with connecting to the audio.
Okay.
Thank
Okay.
you.
All right, counsel, on behalf of Metro, defendant has failed to appear, submit a default.
Okay, let's see. Was there an order in?
Oh, actually, yeah, let's see what we got. Yeah, there's already a default. You're just after your eviction. I'm signing that.
Correct. Yep, a modified one
Yep.
to deem it abandoned.
Yep. No, that's, all right, hold on a minute then. That's a different issue. Yeah, let's talk about that. I've only been doing this for 30 years. I have no idea what authority I have to determine that this house belongs to Metro. I can give a possession judgment for the lot, but what's my authority to determine who owns the property?
So previously, let's see, a judgment was entered. We are past the 56 days for a writ, but what we are seeking,
I know what you're seeking. You want me to sign an order that says you own the home because it's been abandoned. I don't know that I have any authority to do that. That's what I'm asking. Under what authority can I say who owns this mobile home?
not that we own the home, just that it has been abandoned so that we can submit that to the Secretary of State. Because the Secretary of State will not issue title unless there is a court order indicating that it was abandoned.
All right, based on the affidavit of Gonzalez, then I'll sign your order.
And is there a copy of the order in the file?
I've already signed it. Yep.
Okay, awesome. Thank you, Judge. Have a good day.
You as well. You want to bring Carrie in?
Morning, Judge.
Good morning. How are you?
Peachy, how are you?
Better than I deserve, Carrie. We're bringing Miss Markham in right now.
Where's Danny? Is he here?
I thought I saw his name at some point. Didn't we have Mr. Horn in, Paula? There he is.
Here, yeah.
Okay, cool.
For some reason, my participations list has changed. There we go. That helps. All right. Appearances on Mid Apartments versus Markham.
Carrie Sy, P67390 on behalf of plaintiff, Your Honor.
Danny Horn on behalf of the defendant, Your Honor.
Where are we at on this one?
I think that we, I think we have, I apologize, Danny. I don't mean to step over your toes, but it's just, I think it's my personal. But I think that we have both applied for the SARA funding. Ms. Markham has made the payments to my client as we had discussed earlier, but I don't think we told you about that, Judge, but everything's been going very well. So we have the application in. We're just, I guess, waiting to hear back on all of that. I know that my client submitted, I know that Ms. Markham submitted it. So I think that we really probably just need a date in May, Judge.
So what do you want to go? 30 days out? More than that?
No, 30 is enough, I think, because I think the applications are in and maybe we won't even be back before you.
Okay. All right. I'm just going to make a note. Civil Department will pick a date roughly 30 days down the road then.
Perfect.
Mr. Horn, you agree?
That sounds good, Your Honor.
Miss Markham, good luck to you.
Thank you.
You're welcome. Stay
Thank you,
well.
Rob.
Thank you, Your Honor. Thanks, Carrie.
Mr. Horn, will you contact me via email?
Yep, absolutely. I'll reach out to you, Miss Markham. You're
Thank you
welcome.
very
Have a good day.
Thank you, guys.
I'm sorry, what do you got, Mr. Nader?
With Faris Parton, we're ready.
All right. What are we going to do with Miss Parton's file?
She apparently doesn't believe that she owes us because we bought the debt. So.
File a motion?
We will. I think we were just waiting for the discovery. I haven't, like I said, I didn't receive her answer. She claims she sent us some discovery as well, which is, I think she wants to know how much we paid for the debt, stuff like that, based on what we just talked about, but I'll wait to see what her, I guess her discovery is.
I can just adjourn the pretrial if you think that makes more sense while we're waiting for an exchange of docs.
That's fine. Yeah. And then as long as we have time to file the motion for summary, I think we should be,
Okay. All right, Ms. Parton, that makes sense. We'll give you more time to get those documents back and forth.
That's fine. I sent all my documents off. I'm awaiting information from them now.
All right. Let's do this. We'll adjourn it out around 30 days, but if it looks like that's not enough time yet, then just contact the court ahead of time.
Good.
All right?
Do you want to bring Mr. Kanine in for her?
Yeah. Mr. Nader, that's it for you, I think?
No, I still have that one May Melvin.
Oh, okay, yeah, yeah, and I don't see him. Hold on, let me see what that one, when was that scheduled, Mr. Nader?
9:45.
All right, submitted default.
Sounds good. Do you want me, are you guys doing by email or fax or?
We can do it by email. And if you look in the chat, I think Sandy put the email address up in the chat box.
Highlighted in chat, but. Oops. Let's see.
All right, Mr. Beach, where we at?
Your Honor, I emailed the credit card statements to Mr. Qua. And I don't know, we weren't in a breakout room or anything, so I don't know if you guys had a chance to review them or not.
Would you like to be in a breakout room with him? Would that help?
Yeah, for a quick second, yeah, that'd probably be helpful.
All right, let me bring him in so we can put you both in a breakout room.
Okay.
And counsel, how about your appearance on Crown Asset versus Parton?
Good morning, Your Honor. David Canine appearing on behalf of the plaintiff.
Good morning again, Ms. Parton.
Morning.
And Mr. Canine, what do we have on this file?
This is our first hearing, Your Honor. I believe the parties would benefit from some discovery, please.
Looks like this is our third hearing. Right? Crown Asset versus Parton, December 15th, we adjourned it. March 16th, we adjourned it.
I'm sorry, I'm not sure did those hearings actually go? Because we've received a number of adjournments.
Yeah, from my notes, I'd say they went. I mean, I got no problem putting you in a breakout room with the lady.
I don't mind speaking with her, but she just served me with discovery last week, and I think probably wants answers or she wants to settle, so, or even discuss settlement. But I'm not adverse to speaking with her.
Right. Ms. Parton, do you want to talk to the attorney about a settlement, or you just want to wait until you see your answers?
I'd like to wait, please.
Why don't we just adjourn this out so we'll tag it with that last file we adjourned for you?
That's fine.
Around 30 days, Mr. Canine?
Yes, please.
All right. Anything else we can do today?
No, thank you. Not on plaintiff's end.
Ms. Parton, you all right?
Yes, sir.
Enjoy your day.
Thank you. You too.
Thank you, Ms. Parton. Here.
Judge, you wanted me to put Mr. Beach and Mr. Qua in?
Yes.
Thank you. I'm sorry. And Mr. Nader was waiting for Mr. May.
I think he was just waiting to get an email address for Sandy.
Oh, she's put it in there for him.
Why don't you send him a chat, see if he gets that.
That's how she sent it to him.
There was a chat in the waiting room with the email address.
All right. Miss Bailey, your appearance for Jefferson Capital versus Ketchum.
Kara Bailey, P7307, on behalf of the plaintiff today.
This was scheduled at 9:15, right?
10:15.
10:15. All right. Well, it's been a half an hour. What's your pleasure? Oh, this was a motion for summary disposition.
It is, Your Honor. We filed the motion for summary disposition under C9. My understanding is the defendant is not disputing anything in her answer and wanted to pay. At the last pretrial, she actually said she was going to pay everything.
Right.
But it never happened from what I can tell from my file, and she never contacted my office with any issues. So at this point, I am asking that our motion be granted and that summary judgment be entered for a total of $1,328.02. If she still wants to pay that, obviously we are open to that.
Right. Okay. Granted, send in an order.
All right, I will email it over. Thank you.
Perfect. Thank you. Mr. Nader, are you there? Now we lost him.
I sent it to him personally so that he would know it was there for him. Sandy sent it about 2, 3 times.
All right, gentlemen, back on the record with CACH versus Qua.
Yeah, Your Honor, I was able to speak with the defendant, and we discussed some of those statements. And you know, my feeling is I've seen a lot of fraud over the years, but usually, you know, you see a lot of cash advances and stuff like that, and you almost never see payments being made on a fraud account. But Mr. Qua said his brother, who's a suspected fraudulent person who's using his identity, lived with him at that address, and he's adamant that these weren't his charges. There are a couple of suspect charges that I'd like to throw a couple of subpoenas out, Your Honor, if we could adjourn this. There's a charge to the city of Sterling Heights for $522. And there's also right after that, there's a charge to a dental clinic, Comfort Dentistry, for $188.
Okay.
I think a subpoena to those would probably lend a lot of good information. You know, if I could just find out who the person receiving the services were for the dentist and what the nature of the $522 charge was with the city of Sterling Heights.
Sure. Mr. Qua, any objection to an adjournment?
No, sir.
That'll probably take more than 30 days, wouldn't you expect, Mr. Beach?
Yeah, I would. I'll try to get the subpoenas out with the next day or two, but it usually takes at least 2 or 3 weeks to get a response.
Yeah, I'm gonna bump it out 60 days. If you know, we get all our information back early and you want to get together, then just contact the court and we can always stipulate to another date.
Okay, thank you.
All right. Mr. Qua, any questions?
No, sir.
Have a good day, gentlemen.
Thank you. You too.